for the reasons that we've given above, we have decided to withdraw from their court. It is clear that Mr. Alfonso Owinyi-Dolo and the members of his court are not interested in giving Ugandans justice. No, they are not.
Alright, that is Bobi Wine mu bigambo bye wakakasiriza nti omusango agenda kubeera nga gujjayo so zonna details mugenda kubanga muzifuna mu maaso awo ku mulamwa ogw'okuba nti yayise bannamawulire okubannyonnyola ensonga ze ezikwata ku musango ogwo naye nga ekiriwo olunaku olwaleero oba ekitambula ku social media ekiri ku mimwa gy'abantu gye tuliira emmere gye tutambulira gye tusula yonna abantu boogera ku mmotoka ya Bobi Wine empya gye yafunye era n'olunaku olwaleero wasazeeko offices ze olabye nti abantu balaze excitement y'amaanyi nnyo abajjemu essaati ne bazijjamu ne batandika ogirongoosa aboogedde ne babyogera abamu babadde bamaze okubeera nga bafuna ku bigikwatako akwega abamu batandise n'okukiyitiriza bannaaye mu bintu emmotoka eno byekola tegaba mmere mu bintu emmotoka eno byekola tebuuka naye nga yanjawulo nnyo ku mmotoka endala era emmotoka eno ekyenjawulo nti bonna mwabitegedde teyitamu masasi emmotoka eno erina internet ya bwerere emmotoka eno enywa amafuta g'ebika bibiri ebyenjawulo that is diesel ne petrol then ne engine yaayo byonna ebyenjawulo nga mujja mubiwulira byo bigikwatako nnyo bulungi nnyo so ereesewoko embeera ey'okwogera wano ne wali naye nga mu mbeera bwetyo ekirungi yabategeezezza engeri gye yafunyeemu emmotoka eno so engeri gye yamutuuseeko ajja kuba atubuulira naye nga engeri gye mwagimuwaddemu mu mikwano gye giri mu diaspora n'emikwano gye egiri mu Uganda mwakoze omulimu gw'amaanyi nnyo naye nga tudde ku basics za musango so katubeere nga tumubawa ate abeere nga abannyonnyola ebisingawo ku ebyo bye mulaba so nze lujja tuli ku Carlton Music mu nteekateeka 2-2
Much as the judiciary has been reduced to a mockery, it's an institution that we believe in while we might not believe in the people that are pretending over it. And yes, we went, like I told you, we went to the Supreme Court to get two things, either to get justice or to have opportunity to expose the judiciary. But as you all have been following, even before we could expose the judiciary decided to expose itself. The world has been watching the biased tendencies. You have seen the bias and double standards that have been exposed by the judiciary, but in particular the Supreme Court. You all remember that we were blocked from filing our election petition on a Saturday. But when the NRM lawyers went to the Supreme Court, they were actually allowed to file a response to our petition on a Saturday. That is double standard number one. Just a few days after we had filed our petition, you all saw, we watched in shock as the Chief Justice invited the respondent, General Museveni, to a lawyers' meeting. But not only did he invite him, but you all watched the statements that the Chief Justice made before General Museveni. The Chief Justice was asking for some favors and was asking General Museveni to do some things in the capacity of president a year from now. Now here is a situation where the judge in a matter where Museveni is a defendant is actually asking for money from Museveni. We think that is not only immoral, but that is wrong. Now, following that, you all remember, ladies and gentlemen, that I was put under illegal house arrest for 11 days after the election. And yet, according to our laws, an aggrieved party is supposed to file a petition within 15 days. Now, out of those 15 days, I was under house arrest for 11 days. It took the order from the High Court of Uganda for me to be able to leave my home, thereby start working on that petition. Good enough, we were able to work around the clock, and within 4 days, we had filed a petition. But again, our law provides for amending that petition because we decided that we had to present more grounds, more powerful grounds to the Supreme Court. It shocked us, like it shocked so many people in the world, that the Supreme Court rejected the amendment to our petition. I must remind you, ladies and gentlemen, that in the just recent presidential election petition of Amama Mbabazi versus Museveni, an amendment to the presidential election petition was accepted. So it was clearly discriminatory of the Supreme Court to reject an amendment to our petition. Yet an amendment was accepted in the recent presidential election petition. We made every effort to collect as much evidence as possible, even amidst difficulty. So amidst those challenges, we were still able to put together that evidence, well knowing that in the past presidential election petitions, for example, one of 2001 and one of 2006 of Dr. Kizza Besigye versus Museveni, evidence was continuously admitted in the court all through the hearing. But guess what? When we took our evidence to the Supreme Court, even before the hearing, the Supreme Court adduced enough evidence. But here is the Supreme Court rejecting evidence. And among the evidence that was rejected was an affidavit by our Secretary General, was an affidavit by a comrade called Kalundi Serumaga of a video which was putting everything clear to the Supreme Court. Videos of the military ballot stuffing, videos of pre-ticked ballots being ticked by the police and the military, videos of places, especially in Western Uganda, the judiciary, the Supreme Court is not intending to give us justice in this matter. Now, one very disturbing thing is that in the 2016 presidential election petition of Amama Mbabazi versus Museveni, even when by then the days of hearing and determining the case were 30 days, they were given over a week of submissions. But guess what? The Supreme Court said we could only submit in this our petition for 30 minutes. Only 30 minutes. I want you to imagine us being able to make our case, to bring all these details together in only 30 minutes. Now that was clear. One, the Supreme Court did not want this matter to attract so much attention. Because this is a matter of very high public interest, they did not want the public to pay so much attention. They did not want to expose themselves. But unfortunately, they ended up exposing themselves even much more bare. The courts are not independent. It is clear that these people are working for Mr. Museveni, and we refuse to be part of that mockery to justice. We have told you before, and we tell you again, that we are going to take this matter to the court of the people. We have told you before, and we are telling you again, that the people of Uganda are going to have the final say in matters concerning their destiny. We want to tell you, ladies and gentlemen, that this is not the first time this is happening. After what Obote did with the 1980 election, Mr. Museveni went to the Supreme Court. But he went to the court, but he had to abandon that case because the judiciary was just as it is today. So Museveni seems to have been a very good student of Obote. Unfortunately, this is going to be to his detriment. To differ from Museveni, we are not violent people. We are withdrawing from the court, but we are not opting for violence. We are going to the court of public opinion, we are going to the court of the people of Uganda, and we shall be informing the people of Uganda our next steps. We have therefore instructed our lawyers to withdraw the case from Mr. Owinyi-Doro's court, because it seems like that is not a court to give Ugandans justice. I thank you, ladies and gentlemen, for God and our country.